The framing of the U.S. Constitution and the distribution of power. Articles 4, 5, 6, and 7. We've already covered the preamble of the Constitution, so now let's turn our attention to the 7 articles which make up the structure of the Constitution as it was signed. We'll spend some more time later talking about Articles 1, 2, and 3, and so I want to focus on the remaining articles. Article 4 is specifically about the states. Article 5 has to do with amendments to the Constitution. Article 6 deals with debts, supremacy, and oaths. And Article 7 talks about how to ratify. Article 4 has separate clauses in it which talk about relationships between the new 13 states. There are 4 clauses specifically that I want you to be aware of. The first is called the Full Faith and Credit Clause. This is where the states must respect the civil laws, records, and court rulings of the other states. For example, if you get married in one state, you usually don't have to go and get married again in another state in order for your marriage to hold up. If you decide to move from Nevada to California, you don't have to get married again because California has to respect the marriage license which was filed in Nevada. The Privileges and Immunities Clause. This is where states may not discriminate against citizens from other states. What was going on at the time, you have to think about the states as being really their own little nations. They all had their own ways of doing things, and they were very particular about their little cultures and communities that they had built. So this was to prevent, say for example, Massachusetts from telling Rhode Island residents, sorry, but you can't come in here and work in Massachusetts. In order to be in Massachusetts and work in Massachusetts, you actually have to live over here. So that's what this particular clause was for. Extradition is a clause which says that a governor can demand a fugitive be surrendered if he has fled to another state. And so you can think of a fugitive running across the state lines from Nevada to California and then thinking he's home free because he's outside of the jurisdiction that he's escaping. In this case, the governor can actually demand that the fugitive be surrendered by the new jurisdiction he has entered and brought back into the old jurisdiction. And finally, the moot fugitive slave clause. This is where slaveholders could go into free states to capture escaped slaves. This, of course, not being relevant anymore to our society currently. However, at the time, this was a big deal because we had the southern states who still had a very strong slave economy, and you had the northern states with the abolitionists who were more of a commercial economy. And so if the slaves could escape to the northern states, then they would be considered free and they wouldn't have to be under the same bondage they were in before. There were many difficulties with this particular clause, one of the biggest problems being that the way that it was implemented was that you would have slaveholders in the South going up to the North, and because there was no real proof of who your slave was, they would kidnap black individuals who were not slaves at all and who had never been slaves in their lives and say that they were fugitive slaves and bring them down as captives to the South and claim that it was done under the Fugitive Slave Clause. Article 5 talks about amendability. All amending means is to change something and to make it better in some way. And so the Founding Fathers had a decision that they had to make. How do we deal with the Constitution's amendability? Do we keep it rigid or do we allow it to grow in some way? And they decided that actually what we want is a living document. We want something that can be changed, that can grow. We're afraid that if we stick with a rigid document, this may lead to illegitimacy. Remember, the political process is giving power to the government, and the government is made up of this particular constitution. And so if the Constitution becomes rigid and the political process no longer gives power to that government is no longer seen as having authority and having legitimate power, then it's going to break down, there's going to be violence. So they want to make sure that it's flexible enough that this doesn't actually happen. There are 2 ways to amend the Constitution. There are 2 separate processes. One is called Formal Amendment, which is taken care of largely in the legislative branch, and one is called Informal Amendment, and the informal amendments take place in the judicial branch. The formal amendment is the process which is outlined in the Constitution. This is the way that we got our 27 amendments to the Constitution which we have today. There were actually 9,750 amendments which were introduced. Only 27 of them were added. So you can imagine how difficult a process this has been if over the entire life of the Constitution we've only been able to amend it 27 times. Informal amendment, on the other hand, is much, much more frequent, and this doesn't have to do with adding on extra language to the Constitution itself, but it has to do with the judicial branch's power to interpret the Constitution. When there's vagueness in the constitutional language, there's just some uncertainty about what something means, the court can come in and say what that particular clause means. They can give it new meaning, and in doing that, they're informally amending what may be underlying what that clause says and what that clause is, how that clause is going to be applied. This, of course, happens much more frequently, as whenever you have a constitutional question that comes before the court, and the court makes a ruling on that, we have a certain type of informal amendment, be it small or large. Formal amendment can be done in a couple of ways, and I apologize that this slide's kind of cut off at the end, but this is in your book. The formal amendment has to be started in one of two ways. It can be started by 2/3 vote of both houses of Congress, or it can be started by a national convention which is called by Congress if 2/3 of the state legislatures request it. Then, when you've taken care of that first step, then it can go through either one of two second steps. The first one approves that particular amendment by legislatures in 3/4 of the state, and the second one ratifies it through ratifying conventions in 3/4 of the state. On the side of proposal, definitely the 2/3 vote in both houses of Congress is far the most popular. We've used that 26 times, coupled with the approval through legislatures in 3/4 of the state. We've also used the 2/3 vote in both houses of Congress one time in conjunction with the ratifying conventions in 3/4 of the state. Now that gives us our 27 amendments. The second option for proposal, where a national convention is called by Congress at the request of 2/3 of the state legislatures, exists. It's written into the Constitution that we can do that. We've just never actually used it. So it's there, but it's never been tried out, and none of our amendments have actually come into full approval through this matter. Informal amendment, on the other hand, like I said, goes through the judicial branch. And we've done a lot of great things through informal amendment. We've extended the Bill of Rights protections to state actions, we've prohibited child labor, and we've extended equal protection of the laws to children. Now, interpreting the Constitution can be a very tricky thing, and the justices who do this tend to fall into two camps in terms of how they see their job as constructionists or as interpreters of the Constitution. One camp are called the strict constructionists, and the other are the loose constructionists. What the strict constructionists believe is that the Founding Fathers' literal words on the page of the Constitution must be adhered to, that they chose those words very carefully, and that each of those words had a particular meaning. And so the closer you can stay to the literal definition of the Constitution, the better. Loose constructionists, on the other hand, view the Constitution as a living document, and they really look more to what the meaning behind it was. What is the spirit of this particular provision of the Constitution? The Founding Fathers couldn't anticipate everything, so let's see kind of what were their intents and be flexible in what we think the Founding Fathers might have, based on what they did write. What would they have said about this particular issue that's come up, much, much later on in American history? Article 5 also has a no amendment clause. It specifically states that the Constitution may not be amended in only 2 instances. So it goes through this very particular way that we can formally amend the Constitution, and then it says, but there are 2 instances where you may not amend the Constitution. Just 2, mind you. And I want you to think about all the different things that we've learned about that are already in the Constitution. For example, Articles 1, 2, and 3, which talk about our branches of government. Article 4, which has those separate clauses and talks about the states. So in this particular clause, we hear from the Founding Fathers what their two most important pieces of the Constitution were from their point of view. Number one is that Congress may not prohibit slavery before 1808. And number two is no one can deprive the states of their equal vote in the Senate without their consent. So you can take a look at this, and this is very interesting because you can say these are the two things which the Founding Fathers at the time thought to be the most important. You can amend out having a president of the United States. You can amend out having a judicial branch, but you may not amend out prohibiting slavery before 1808. So very interesting, shows you somewhat of the dynamic of what was going on in the room at the time. Article 6 deals with debts, the Supremacy Clause, and oaths. What the Supremacy Clause is it tells us that the Constitution shall be the supreme law of the land. And it lays out for us a hierarchy of the law and how it is to be followed. Think of the different types of law that we have in the United States as a pyramid. At the very top is the Constitution. That law supersedes all others. Second, underneath that, we have federal laws and U.S. treaties. Underneath that, we get to the state section, where we have the state constitutions followed by the state laws. Whenever a higher piece of law on the totem pole contradicts something that's on the lower part, a lower section is said to be preempted. This is called the doctrine of preemption. So in other words, if anything disagrees with the Constitution, say there's a state law which is written which disagrees with something the Constitution says, the Constitution will have said to preempt the state law by preempting the field in that particular situation, and that state law will not be able to stand against the Constitution. Article 7 discussed ratification. Now that we had a Constitution draft that was in place, it had to be approved by the 13 states. And so ratification, all it is a process of voting on and approving something. In this particular instance, we needed 9 state conventions to ratify the Constitution in order for the Constitution to go into place as the supreme law of the land. We had New Jersey, Delaware, and Georgia sign on immediately. It was unanimous. So you can take a look at the orange filled in states in the box over here. And those were the ones who immediately were on board, voted unanimously in their state conventions to ratify. Connecticut and Pennsylvania were shortly behind. They were strongly in favor, and they also ratified. And then Maryland, Massachusetts, and South Carolina also ratified through their state constitutions, though they didn't have as overwhelming a response. So if you've been counting along with me here, we actually had 8 states which were already ready to ratify the Constitution. Everything was in place, but we still needed one more. And this brought us to ratification battlegrounds. We had Virginia, New York, New Hampshire, Rhode Island, and North Carolina, which were still in play. And remember, we only need one more, and this would become the law for everybody. And so we had the Federalists and the Anti-Federalists traveling to these states to try to persuade the states one way or another. The fiercest debates were in Virginia, New York, and New Hampshire. The Federalists and the Anti-Federalists were actually the earliest political parties which we had in the country, and if you can think about all of our delegates that we had in the room, they were actually separated out into these two parties and had very differing ideas of how the Constitution should play a role in the states' lives. The Federalists, on one hand, were very much in favor of the Constitution. You can think of George Washington, Ben Franklin, John Adams, and Alexander Hamilton, some big names here that I'm sure you've heard before. They were very aggressive in organizing their media blitz on these states. They really wanted to get out the message that the Constitution was a great thing. You've heard of the Federalist Papers, likely. These were essays which were sent around that talked about government and talked about what was going on, and they definitely touted the Constitution as something positive. They had an economic stake in the new union, and they wanted security, order, and control over the popular masses. So they really wanted to be able to do this through the Constitution as it was written. The Anti-Federalists, on the other hand, Thomas Jefferson, Patrick Henry, Sam Adams, John Hancock, they really were much more closely aligned with states' rights. They were we were still afraid of this umbrella organization that was to be called the Constitution and the United States of America. We were really afraid that you'd be taking away from us the rights that we had. They were very much rural rooted, and their values really had to do a lot with anti-corruption and really being more of a smaller power. They said, we really don't have to go out there and be a world power, be a huge nation. We really just want to pay attention to our small governments. We don't want this big bureaucracy. We just want something small. And they also, for the first time, put forth this idea of a Bill of Rights. So you can kind of see beginnings here of our popular and our newer political parties which exist in the modern era today. And when we talk about political parties, we'll talk about this a little bit more. But you can kind of see this idea of small government versus big government, popular control, and aggressive management of a nation versus really the smaller control in state governments. They're starting to emerge here, which still have themes which run today. The Federalist Papers, as I mentioned, were essays, and they were collected, and they were actually published under a pseudonym. The pseudonym was Publius, and it was actually the writings of three separate authors. It was James Madison, Alexander Hamilton, and John Jay, and they wrote a couple of different essays to help people decide what the Constitution was about and what they should be thinking in terms of things they should be adding or setting, to their debates when they talked about the Constitution. Federalist Paper number 10, written by James Madison, warns about political factions. He says, "The most dangerous is the mass or propertyless whose behavior was threatening to property owners under the Articles." When he's talking about political factions, he's talking about groups, particularly these groups who are coming together to do things like overthrow the government that they have. He also called for a republic. The idea of the republic was to have representative democracy. We want to dilute the effects of this group of people, this group of the masses. How can you dilute that? Instead of having direct democracy, you give them a republic in which they only have one representative to speak for them, and therefore their voices are minimized to a certain extent. Federalist Paper 51, Madison suggests the whole idea of checks and balances and separation of powers. He suggested them as institutions to protect against the tyranny of majority, and really this was his idea that he brought to the Constitutional Convention that was put into place. And then in Federalist Paper number 84, Alexander Hamilton says, we don't really need a Bill of Rights. And actually, a Bill of Rights might be dangerous to add to the Constitution. Because if we add a Bill of Rights to the Constitution, then the government might think that those are the only rights that people should have. This, of course, didn't carry the day. It was an argument that he put forward, trying to persuade people that, in trying to persuade people that the Bill of Rights would not necessarily be something which was healthy to include, but there were still a whole lot of parties, individuals, and states who believed that a Bill of Rights was absolutely necessary. What it came down to is that some states just straight up refused to ratify the Constitution without a Bill of Rights. What the Bill of Rights would be was a listing of protections against government infringement of individual rights guaranteed to the citizens by the government itself. North Carolina actually defeated the Constitution. They brought it to a vote, and the Constitution lost 193 to 75. Rhode Island refused to call a convention altogether to put it to a vote and just said, we're not even going to deal with this at all. This is ridiculous. And so, with the Federalists realizing that they were losing ground with these states, they decided to promise a Bill of Rights if these states would go along with ratifying the Constitution. And so we have eventually all 13 states ratifying the Constitution. The last states ratified in 1789, that was 1789 and 1790 rather, that was North Carolina and Rhode Island. And then we got the Bill of Rights, which is the first 10 amendments to our Constitution, written in 1791. So it came right on the heels, as promised, to the states who demanded it in order to go forward with this. All of the rights that we have as citizens come out of the amendments to the Constitution. You'll notice as we talked about the structure of the 7 articles, there really wasn't anything in there that we think of when we think about, say, our First Amendment rights, our freedom of speech, and our freedom to bear arms, and our freedom to a jury trial, for example. All of that came out much later. Now, this is the entire Bill of Rights written here. You can see it all fits on one slide, and you can actually read through the entire thing fairly quickly. The First Amendment of the Constitution has the freedom of religion, the freedom of free speech and press, freedom of assembly, freedom of petition. The Second Amendment is your freedom to right to bear arms. Your Third Amendment says that you don't have to feed and house soldiers who are in your house. This was a big deal because when the British were sent over to keep watch on the colonists, whichever British soldiers were sent over there weren't sent with any provisions. So they could be quartered, that is, put into your house, and you had to take care of them, feed them, make sure that they had, the best room in the house and everything like that, or at least had a sufficient place to sleep, and you really didn't have a choice in the matter. So they wanted to write that in to make sure that couldn't happen. Article 4 has to do with a lot of criminal procedure. This is the right of people to be secure in their persons, houses, and papers. You have the right to be free of unreasonable searches and seizures in here. Talk about warrants and probable cause that in order to search or seize things. Article 5 has a whole bunch of stuff in it, but as you can see, actually, it's only about 5 lines. But it has, for example, that you get an indictment of a grand jury if there's a capital crime. You have the right, for example, to you have the right of eminent domain, which is in there somewhere, to be compensated for a taking of property. You have the right not to testify against yourself if you don't want to. This is where pleading the fifth comes from. And you have the right to not be put in twice jeopardy, no double jeopardy. If you've been tried for something, you can't be tried for the exact same thing again that arises out of the same set of facts. Article 6, we have the right to a speedy and public trial and to the assistance of counsel. Article 7, we have the idea of a trial by jury in a civil suit. Amendment 8, have I been saying article this whole time? Amendment 8 says there's no excessive bail that can be put out and no cruel and unusual punishment. Amendment 9 talks about certain enumerated rights in the Constitution not to disparage others. And Amendment 10 talks about powers not being delegated to the United States as a whole, nor prohibited to the states, are reserved for the states. So if it doesn't say that you specifically have to give a right to the United States, then it goes back to the states and states' power. So it's very, very short. I would suggest that you take a minute just to read this over, because this is where all of these civil rights and civil liberties come from. Well, we have a couple of them that are going to come up in later ones as well, when we get to the 14th Amendment, for example. But this is really the start of any type of right or any type of civil relief for individuals. It was not really thought of at all. Constitutional Convention. It really wasn't about the people and their rights, and everything about how to set up a structure of a functioning government. The government wasn't there specifically to protect the rights of individuals. It was there for a different purpose. And so with these amendments, you can see how chock full this was of what we see today, enforceability for individual rights that hadn't been put in there before. You can see all of these things which came into play actually the year after the Constitution was ratified by the 13 states.